You've just received an adjudication determination ordering your practice to pay a structural engineer for redesign work that was caused by their own detailing errors. The adjudicator has completely misread your subconsultant agreement, and your instinct is to challenge the decision for bias. Before you pick up the phone to your lawyer, there are 4 things you need to understand. First, errors of contract interpretation are rarely enough to overturn a determination. Under the Building and Construction Industry Security of Payment Act 1999, adjudicators are permitted to get the law wrong. The New South Wales Supreme Court will only intervene if you can establish a genuine jurisdictional error, such as a denial of natural justice or apprehended bias. A simple misreading of your coordination clauses, no matter how frustrating, is unlikely to meet that threshold. Second, the bias threshold is exceptionally high. The test is whether a fair-minded lay observer might reasonably apprehend that the adjudicator lacked impartiality. That means the adjudicator's familiarity with the project, prior rulings against your practice, or even your own criticism of them in earlier proceedings will not, on their own, be enough. You need to demonstrate something far more pointed, such as a personal financial interest in the outcome of your dispute. Third, even if you succeed, the court may not void the entire determination. Under Section 32A of the Act, the Supreme Court can sever the portion affected by jurisdictional error and leave the rest intact. So if the reviewable error only touches one variation line item, you could spend tens of thousands of dollars on legal fees and still be liable for the balance of the subconsultant's claim. And that brings us to the 4th and most important point. Your real defense is the payment schedule. Because Supreme Court review is difficult, expensive, and subject to severability, you must front-load your position long before an adjudicator is ever appointed. That means articulating precisely why you are withholding payment, identifying the specific contractual clauses, the coordination failures, and the evidence, all within the statutory timeframe. If your practice is facing a subconsultant payment claim and you need to get your payment schedule right, contact Merlo Law for early dispute strategy.